A very, very warm welcome to all of you, dear participants, to this lunch webinar. My name is Pascal Pichonnat, and as president of the European Law Institute, it is a great pleasure and my privilege to welcome you to this webinar to discuss today the feedback and especially the ELI feedback on the European Commission published two drafts, one on the proposed new product liability directive, and of course attached to it the draft AI Liability Directive. You know that these drafts have been published on the 28th September 2022. The ELI feedback was prepared by an ELI team under the leadership of Professor Bernard Koch and Professor Jean-Sébastien Borghetti, and chaired by the ELI Scientific Director, Professor Christiane van der Horst. Of course, this ELI feedback is based on prior work that the ELI has produced in this field, most notably the ELI draft of a revised product liability directive, as well as the ELI response to the former public consultation of the EU on this subject. The webinar aims, therefore, to continue the dialogue on the reform of this product liability directive, a very important reform, and therefore we are very happy to have such a great panel today to discuss that. But before beginning, let me remind you that the chat function has been disabled, so your questions can be posed but through the Q&A section, and therefore you will be able to ask questions throughout the presentations of our panelists, and at the end we will have about 20 minutes for a Q&A section where we will try to answer all your questions. So it's time to start, and let me briefly present you the three main the two reporters and the chair of the ELI panel that prepared this response. First of all, Christiane van der Horst, who was the chair, as I said, of the group, and she prepared also, of course, part of the response and other documents. She's professor of civil law at the University of Vienna, former president of the European Law Institute until 2021, and since 2022 she's scientific director of the European Law Institute. Among other functions, she's also division president of the humanities at the Austrian Academy of Sciences. Then we have Professor Jean-Sébastien Borghetti, professor at Université Paris-Panthéon-Assas, or Paris 2. He specializes in contract and tort law and is member of the European Group on Tort Law and the World Tort Law Society, as well as a member of the EU Expert Group on Product Liability and New Technologies. Bernard Koch, then, he is professor at the University of Innsbruck, ELI council member and co-reporter of this project with Jean-Sébastien Borghetti, currently Dean of Studies at Innsbruck University, and he's also a member of the European Group on Tort Law and former EU Expert Group on Liability for New Technologies. So with no further ado, I will give you the floor, and I think that you are beginning, Bernard, so you have the floor.
Thank you very much, Pascal. Welcome to all of you on site and at home. The European Law Institute was really happy to see the two drafts in September. We and I personally think that the draft is a major step forward and includes several very important improvements. So we're really pleased to see the draft as it was published in September. However, due to time restraints, we have only about 15 minutes for the three of us. Unfortunately, I'm in the position to just point to some points of possible improvement. So this sounds way more critical than we are, but still, I just have to focus on points where I think there might be further thought or reverting perhaps necessary in order to make it even better. The first point, and obviously the most important aspect of the whole new draft, and perhaps also the trigger for the draft process in the first place, is the question of including software in the notion of a product. And that, of course, a major leap forward. And obviously, as you know, and I assume that you all have read the draft, this is expressly mentioned now in the definition of a product in the draft directive, and that is definitely a huge advancement and improvement. However, we think that the term software as such would need some black letter definition of sorts. And obviously now this is easy to say if you don't have to propose a wording for that. But I assume that it might be easier to at least include a negative definition, because there are some aspects that are open to debate with the wording. If you compare the general definition of software in various linguistic books such as Merriam-Webster or Britannica or whatever, you come up with a wide range of definitions. And there are some points in the preamble that obviously help us to understand this further, but I think this deserves at least some mentioning in the black letter text, starting, for example, with the exclusion of open source software, which is merely mentioned in the preamble, but not in the black letter text, unlike other drafts that we have seen in the past, for example, the Digital Content Directive. But the most important aspect, I think, that needs to be added or clarified in one way or another is the question of what kind of software is included. Is it really just software in the sense of self-executing software, or does it include further digital content? Now, obviously, I assume from the context that mere data content as such is not included. But again, it may be very helpful for readers of the draft to have that spelled out in black letter text. Also, it is a novelty, but obviously due to the restraints and necessities of the problem, that some aspect of digital services are added to the notion, but this is only mentioned with regard to components. And this would basically mean that the new directive would, for the first time, have a different notion of component and product, which I think is unfortunate. Traditionally, under the old directive, a component could only be something that was a product already, with some exceptions, obviously. But the very positive inclusion of digital services in the notion of components is also needed, at least to some extent, in the initial definition of a product. And the most crucial aspect thereof, obviously, is software as a service, which as it stands now is not entirely clear whether it falls within the scope of a product or not. And I think it should. There is no debate that it should be part of the notion of a product, because there is no logic explanation why to distinguish the provision of, I don't know, some office software as a service contrasted to a package deal that you buy in a single download or something. So that's something that I think would definitely need clarification. There are also some aspects, sort of leftovers from the debates around the old directive, which are not equally important, but could at least be considered for the preamble, such as, is waste or human body parts, is that a product within the meaning of the directive or not? But the most important part, I think, is the expanded notion of software and a clarification what falls under which category. And linked to that is the problem of refurbishment. As I understand it from all the publications surrounding the draft, refurbishments should be included under the notion of substantial modification. However, we thought that this is rather unfortunate, because a refurbishment does the opposite of a substantial modification. It tries to bring the product back to the safety expectations of the original product. So it's definitely not a substantial modification. Now, there are two possible ways. Either you exclude refurbishment altogether and really just limit it to substantial modifications, which is a policy choice. But if you want to include refurbishment, I think it would have to be spelled out, because there are different aspects regarding, for example, possible defenses and the relationship between the original producer and the refurbisher. So that, I think, is a very important aspect, which also needs to be considered at least. Now, moving on to the question of liable persons, there is now an expanded cascade system of liable persons, obviously based on the original concept of the 1985 directive, with some additions, and the whole concept as such in general makes sense. However, I think there are some problems of I think, just redaction problems. For example, the definition of the authorized representative and the importer include the limitation to establishment within the EU, which essentially contradicts Article 7, paragraph 3, where you say that if there is no authorized representative and importer in the EU, which doesn't work because they by definition have to be established within the EU. So there is a contradiction in the text. But more importantly, I think, and I will wrap up my part with that, is the role of the fulfillment service provider. Now, we understand the idea that the fulfillment service provider sometimes performs equal functions as the importer, and basically aids the manufacturer to bring a product from outside of the EU into the common market. But I think it would need further thought how to define the service provider, and also the full-fledged exclusion of transport services, even if they do add additional services and are basically in a constant business relationship with the manufacturer and thereby essentially perform functions like a full-fledged importer. That, I think, needs some further thought at the end of the day. Also, the ranking of the fulfillment service provider is not entirely convincing in the whole interplay with online platforms, depending upon, of course, how the definition of the fulfillment service provider is finalized. But that, I think, is not entirely convincing as it stands. But we understand the idea behind it, but the overall balance, I think, would require further thought. And I think I can now pass on to Jean-Sébastien. Thank you.
Thank you, Bernard. Thank you. Well, hello, everybody. So to speak about other aspects of the draft, another one that deserves attention is compensable damage or harm. So in the draft, there is no specific article or provision, well, no specific article devoted to that. It's only addressed in the definitions, which is not too important, but maybe it underplays the importance of that aspect. So a striking fact is that the draft says that only natural persons are able to rely on the directive, so on product liability. In practice, it doesn't make a great change from the current directive because the types of damage that can currently be compensated concern mostly natural persons. But it does express a well, the intention to restrict the scope of the product liability directive to consumers, which is also clear in the types of harm that can be compensated. So this is clearly a political choice, which, well, we can disagree with, but of which we've taken note. Now, if you look at the types of harm that can be compensated, you have, of course, bodily injuries, and also which includes psychological harm, which we think is fine. Then there is damage to property, and here we have the issue of dual use property, because we know that today many things that we own are used both for professional and non-professional purposes. And the good thing here in the draft is that it's only property that is used exclusively for professional purposes, which is excluded from compensation. And another striking thing is the extension of compensable harm to loss and corruption of data, which is, you could say, the flip side of including software in the directive, and that, of course, is fine. A point which we think would need clarifying is what happens with the types of loss or damage that are not explicitly covered by the directive, because today, under the case law by the ECJ, all types of loss or damage that are not covered by the directive may nevertheless be included by member states within the scope of product liability, because it's, well, outside the scope of the directive, and so the member states are free to do what they wish. We're not totally convinced that this solution should be maintained. It's clear that it should be maintained as far as non-pecuniary secondary losses are concerned. So pain and suffering, member states should be free to decide whether to compensate or not pain and suffering. And this is indeed suggested by one recital of the draft. The issue we have is about the types of primary harm that are not included in the draft. For example, damage to professional property. As law stands today, member states would be allowed to include those types of primary harm within the scope of product liability, even though they have not been included in the draft. We don't think this should be so. I mean, if the European legislator does not include certain types of primary harm within the scope of the directive, then it should be made clear that member states are not free to go against that choice and include those types of primary harm, like, once again, damage to professional property. Just to be very quick, on defectiveness, we haven't got much to say, because basically the current definition of defectiveness has been retained. There are some slight, not really changes, rather adjustments or precisions, which are mostly welcome. Of course, some slight points could be discussed, but it's not the most important point. What we would like to outline are defenses. Most of the defenses are taken over from the current directive, so nothing new there. But there is one defense which is very important practice, which is prescription. And as you know, there are actually two delays in the draft as in the current directive. So it's a normal prescription period of 3 years, and then a long stop period of 10 years, starting from basically the putting into circulation of the product. We've got two issues with that long stop period. The first one is that the starting point doesn't take into account the fact, which is taken into account on other issues, that the producer can retain control over the product after the initial putting on the market. So for example, if you've got updates and upgrades, but this will not affect the start of the 10-year long stop period in the text as it stands. So this is not totally coherent. The other point is that this 10-year long stop period is problematic in case of latent personal injury. This point has come up in a case by the European Court of Human Rights, which said that a 10-year long stop period, which came to its end before the claimant had known about its damage, violated the right to a fair trial. And so there is a risk that the application of the 10-year long stop period will lead to a breach of the European Convention on Human Rights, which would of course be problematic. So the draft addresses the issue by saying that in case of latent personal injury, the delay will be not 10 years, but 15 years. We're not convinced that this is enough to solve the problem, because there are cases where the latency period is more than 15 years. So we believe that the best thing would be just to get rid of the 10-year long stop period in case of bodily injury, something which has been done in several legal systems. Of course, it creates extra burden for producers, but experience shows that it can be insured against. And otherwise, we don't see what the solution is to avoid a contradiction or a potential contradiction with the European Convention on Human Rights. And I'll stop there and hand over to Christiane.
Well, thank you so much, and also a warm welcome from myself. I'm going to add just a few words on the relationship between strict liability and liability for non-compliance with certain obligations, in particular with regard to AI risk. In its own draft, the ELI had included a chapter number 3, which does not find any counterpart neither in the previous PLD nor in the Commission draft PLD. And this chapter was on liability for non-compliance with obligations under product safety and market surveillance law. Now, such obligations following from product safety or market surveillance law may be of a very different nature. They range from ensuring conformity with essential safety requirements in the first place, to monitoring the product, to cooperating with authorities, to taking corrective actions such as an update over the air. Now, the ELI found that adding such a chapter to the PLD might be very beneficial for a number of reasons. Clearly, any liability for non-compliance with obligations under product safety and market surveillance law would be very close to fault liability. The ELI didn't really explicitly call it fraud liability, but it is very close to what the other Commission draft, the Directive for AI liability, now treats as fraud liability. Now, why do we believe it would be beneficial to have such a chapter? Obviously, it would be very important for victims in a number of cases. For example, where the producer has a defense under the product liability directive, such as the defect was due to compliance with mandatory legal requirements or with mandatory regulation issued by public authorities. But there are also a range of further economic operators that have obligations under a product safety and market surveillance law, and that do not necessarily are not necessarily now liable under the draft product liability directive as we have it on the table. But you might, of course, say that victims can now resort to tort liability under member state law. But exactly this is the problem we see. And it's close to the problem which Jean-Sébastien has just described. Because victims will, for such cases, resort to tort law under national law, we see a vast fragmentation of the internal market. We believe that this is detrimental for the idea of having a level playing field. And this is why we would suggest to have a higher degree of harmonization, also with a view to enhance consistency of the acquis. Now, of course, it would be possible to have this in a kind of sectoral way. You could have legislation just for AI or just for particular products, but we believe that it would be very beneficial to have a technology neutral solution in the PLD itself. Now, given that we are already over time, I will restrict myself to just mentioning that given that also the Artificial Intelligence Act is product safety law, this would have very important consequences also for liability for artificial intelligence, because this would cover any kind of non-compliance with obligations with either the provider or the user or other parties covered by the Artificial Intelligence Act have under that act. And you could extend such liability in the PLT to harm for pure economic harm, and potentially also to harm that results from risks for fundamental rights. Thank you very much. I will just leave it here because we don't have much time to go into the details.
Thank you very much to all three of you. I think that's already very useful, and I'm sure also in the discussion we will be able to come back to some of these points. I have now the pleasure to give the floor to Urs Buschke, Senior Legal Officer at BEUC, the European Consumer Organization. And before joining BEUC, he worked as attaché at the Permanent Representation of Germany to the EU. So he has always been very much involved in these processes. And he holds also a doctorate in EU law from the University of Freiburg in Germany. And I'm sure that BEUC has a lot to say on this draft. And so I'm giving the floor to you immediately. You have the floor.
Thank you so much for the introduction, and thank you for inviting me and for giving me the opportunity to present BEUC's view today on the European Commission proposal for the PLD. BEUC, the European Consumer Organization, has been calling for a revision of the PLD for several years now, and therefore we very much welcome that the Commission has finally put forward its proposal. Before commenting on the proposal itself, I would like to recall why the PLD is so relevant for consumers. The objective of the PLD, as we all know, is to allow consumers to claim compensation if they have been harmed by a defective product. But what is important here is to point out that the PLD as a legal basis for compensation only becomes relevant if defective products are sold despite the existence of rules which aim at preventing harm in the first place, in particular product safety rules and market surveillance rules. This is why I like to compare the PLD with a safety net for consumers, which protects them in case these other instruments fail. And because the PLD should serve as a safety net, it is so important to close loopholes in the PLD that would leave consumers unprotected. And with this picture of a safety net in mind, I would like now to turn to the proposal and comment 5 points. The first point is the notion of product, and this is a point that you have also addressed, or previous speakers have already addressed. We believe that the PLD should cover all kinds of products, tangible or not. And of course, nowadays, software is of particular relevance for consumers, be it as a component of a smart product, as a standalone product, or as a service. And therefore, we very much welcome the proposal to explicitly include software in the scope of the PLD. The second point I would like to make is on the defect in Article 6 of the proposal. We believe that the list of circumstances which must be taken into account when assessing whether a product is defective or not should be complemented with further circumstances which are relevant for new technology. And in this regard, we welcome the proposal to extend this list, in particular by including the foreseeable misuse, for instance, by malicious third parties. I'm thinking of hacking here. The self-learning ability of, let's say, AI-driven products, the interaction between IoT products, and also to take into account cybersecurity requirements. The third point I would like to make is about damage in Article 4 of the proposal. Here, our position is because the PLD should serve as a safety net, all damages should be covered. And this means, first of all, that the existing €500 threshold for harm should be abolished, because according to the Commission evaluation of the PLD, this threshold has impeded access to justice in 4 out of 5 cases. I think that's quite a number, 4 out of 5 cases. And therefore, we very much welcome that the Commission proposal does not contain such a threshold. But most importantly, we are convinced that the PLD should cover not only material damage, but also non-material damage. For instance, suffering a shock or pain as a consequence of personal injury. And in this regard, I would like to recall that compensating non-material damage wouldn't be new to EU law. We already have pieces of EU legislation that contain compensation for non-material damage. For instance, the GDPR, as you certainly know, but also other pieces like the Package Travel Directive, the IP Enforcement Directive, or the Trade Secret Directive. We simply don't see a reason why victims of non-material damage should be entitled to claim compensation if the damage was caused by a privacy infringement or a breach of a Package Travel Directive or an IP infringement or infringement of trade secrets, but not if the harm was caused by a defective product. Therefore, our point here is that the revised PLD should cover both material and non-material damage. The fourth point I would like to make now is on liability of online marketplaces on Article 7 of the proposal. We believe online marketplaces should be subsidiary liable, even if they only act as intermediaries, because they're responsible for the dissemination of millions of defective products that may harm consumers. I'll give you some examples. The mystery shopping of our members in recent years had shown that out of 250 products that were sold at online marketplaces, 165 products did not meet EU product safety standards. I'll give you some examples. We found smoke alarms that did not detect smoke. We found cosmetics that contained harmful chemicals and toys that were dangerous for children. And I think these examples clearly show that online marketplaces are selling dangerous products, even though product safety rules and market surveillance rules have been put in place to protect consumers. And now imagine What if your son or daughter would get seriously injured by an unsafe toy that fails to comply with EU safety rules, but was sold online nevertheless? We thus agree with the Commission that online marketplaces should be liable. However, we think that the conditions for the liability of online marketplaces in the proposal are far too narrow. In our view, online marketplaces should be liable either if the third-party vendor is located outside the EU, or if the vendor is located inside the EU, if the online marketplace fails to disclose the identity of the third-party vendor. The fifth and last point I would like to make is on the burden of proof in Article 9. Given the incredible complexity of new technology, we believe that consumers should not have to prove the defect, but only the damage. According to the Commission evaluation of the PLD, 50% of all liability claims are rejected because consumers are not able to prove the defect. I mean, this figure clearly shows that placing the burden of proof on the consumer undermines the consumer's fundamental right of access to justice. And the situation is getting even worse because the EU expert group on liability for new technology has found that the features of new technologies will further widen the information asymmetry between manufacturers and consumers, and will thus make it even more difficult and more costly for consumers to claim their rights. And I mean, of course, the proposed rules on the disclosure of evidence and the proposed presumption both aim at easing the burden of proof for consumers and therefore are steps into the right direction. But we believe, nevertheless, that these rules won't be enough to counterbalance information asymmetry, in particular regarding complex new technologies, and thus won't be enough to ensure access to justice for consumers. So to conclude, I would like to sum up our main point, which are that software should be covered by the PLD, the definition of the fact should be broader, taking into account typical features of new technology, material and in particular non-material damage should be compensated. Conditions for the liability of online marketplaces should be broader, and the burden of proof for the defect should be shifted. Many thanks for your attention.
Thank you very much for these very interesting points on which we will come back, and maybe already now with the so-called industry representatives' view on aspect of the directive with Karina Stan. Karina Stan is Director of EU Policy for Developers Alliance. Developers Alliance is a global trade association whose mission is to advocate on behalf of software developers and the companies that depend on them, support the industry's continued growth and promote innovation. And she too previously served as legal advisor and internal market attaché at the permanent representation, but of Romania to the EU. In that position also, she negotiated on behalf of the Council of EU during Romanian presidency on the platform to business regulation. And therefore, I'm sure that the insight she will bring now on the industry representatives' view will certainly be very interesting. Karina Stan, you have the floor.
Yes, thank you very much. We are looking at the proposal for the revision of the Product Liability Directive in the context of a growing significant increase of regulatory burdens for software developers, because we have a lot of digital regulations these days. Our main concern is relating to the scope, to imposing a strict liability regime on software in a generalized way, and I underline, in a generalized way. There is currently no legal vacuum when it comes to software liability. On the contrary, we have software covered by specific requirements in sectoral regulations, for example, to address high-risk specificities of certain sectors like medical devices, that's the best example. We have contractual and national tort liability that covers a broad range of damages, including from services. And consumers can rely on these regimes for situations involving standalone software as well. We think that the generalized inclusion of standalone software in the definition of product is not justified, and because there is a vast range of software applications with various features and functions, and there are a multitude of situations with different levels of risk and also different levels of control from software developers. And in general, when we look at software applications, the nature of software makes it more akin to services. And our concern is that the proposal doesn't clearly delineate between product, what is a product, and what qualifies as a service. We see the proposed definitions of component and related services that are intended to cover digital services, as recital 15 indicates. But while in certain cases, software might qualify as a component of a product, if we think about operating systems, yeah, so a mobile device won't function, like a smartphone won't function without an operating system. Many software applications run more like a service provided to users. We have apps, again, from our smartphone that we download from app stores, or we have web apps. We have in recital 12 a description, but it's quite imprecise in our opinion, of different types of software that are presumed hazardous. And we think there is an unclear justification for the proposed approach to cover just everything. And we think also when it comes to terminology that it gives rise to confusion and legal uncertainty, which is quite of the contrary with the objective of the proposal. And we would agree, it was said before, that PLD, we see it as complementary to product safety legislation, indeed. And I'm thinking about cybersecurity vulnerabilities that are specified in the revision. And in that sense, we are looking at the scope of another proposal, the Cyber Resilience Act, which scope, again, is unclear because it refers to products with digital elements, and it doesn't offer a clear understanding of the products in scope, especially with regard to non-embedded software and software as a service. And it is also unclear if the scope includes only software essential for products functioning, again, strictly under the control of the manufacturer, or other application as well. So it is obvious, in our opinion, that the co-legislators will have to ensure due correlation between the scope of these two pieces of legislation. I won't refer to liability of AI, minding the time constraints, because that deserves an entirely different webinar. I will just make a special note on the exception for free and open source software. It was mentioned in the beginning. We welcome the intention to exclude free and open source software from the scope, and we see recital 13 that is very clear about it. But we think that it has to be strengthened. It has to be reflected in the operative part of the directive, because there is unclarity in relation to the two definitions, making available on the market and putting into service, which includes circumstances where products are placed on the market and distributed free of charge. So I guess this should be clarified. And I like to underline that given the prevalence of open source in software development, a strict liability regime for software in general, again, in a generalized way, will defeat any incentive to utilize open source resources for commercial applications. So software developers use open source code in building different applications because reusing code is very efficient, is saving time and money. And they, in the context of a strict liability, they would be forced to review each piece of code and to duplicate efforts, and also that gives, you know, high costs for any application that is reusing the same snippets of code. So the obvious choice in such a context will be to write code from scratch and to rely on proprietary software. So in their choice, the co-legislators will have to consider the consequences of imposing such a strict liability regime for software in a generalized way, because that will have a significant impact on software development and availability of software in the EU. And that will, of course, will affect the small developers and startups with limited resources, because they will be discouraged by increased legal risk and costs that are associated with litigation, with indemnity to platforms, to device manufacturers, to distributors. So just to conclude, we call on the co-legislators to clarify the scope, what is a product, what qualifies as a service, in correlation with other legislation, relevant legislation. Also, what should be covered by a strict liability regime, because it would be disproportionate to apply such a strict regime for any type of software. Again, we are not in a legal vacuum with regard to software liability today. Thank you.
Thank you very much. Thank you very much for this very clear statement as well. And I have now the pleasure to continue our roundtable with, again, an industry representative's view on the directive by Alexei Varavka. He's the head digital and competitiveness at Independent Retail Europe, which is a European association that acts as an umbrella organization for the main groups of independent retailers and for the main groups also of association in the food and non-food sectors. It brings together something like 23 groups of independent retailers with their 400,000 independent retailers, providing more than 6.5 million jobs, it says, in Europe. And therefore, we are thrilled to listen to what you have to say about these various points. Alexei Varavka, you have the floor.
Thank you very much. And thank you very much to ELI for inviting us to this discussion, which is very important for retailers. I mean, retailers distribute products that have been produced by manufacturers or been imported by importers. So it's a very important directive to ensure that you have actually legal certainty as to which economic operator is actually liable in case you have an injury caused by the defective product. I'd like actually to bring 2 points to the discussion this afternoon. The first, I mean, both of them were mentioned by the previous speakers to different extents. The first one is about actually how the proposal of the PLD addressed the case of refurbishment and repair services. And as I was explained already, I mean, Article 7 actually explicitly attributes the status of manufacturer to any entity that makes a substantial modification of the product. That is very coherent with the General Product Safety Regulation, on which the Council and the Parliament just found an agreement some weeks ago. But that means that quite likely that refurbishers and repair services are excluded from the scope. And we have heard before from previous speakers that it raised some questions, but we see as Independent Retailer Europe that it actually has a number of merits in this approach for 3 reasons. Well, first of all, we are at the moment where the EU is trying to push as much as possible for a circular economy. And that will require to boost the development of repair services, of refurbishment services, to make sure that you really truly have a circular life to any product. And making refurbishing or repair liable as a manufacturer when you are replacing like-for-like spare parts would certainly put a hard brake on the development of such services. you can imagine that a small retail shop that is interested in actually providing some repair services, if he's being told that even if you provide a good repair with like-for-like replacement of spare parts, it could become suddenly liable as a manufacturer, he will think twice or three times before actually engaging in that activity. Also, I mean, you have to consider that if you are replacing like-for-like spare parts, it's very unlikely that it will have any impact on the safety of a product. So the defectiveness of a product causing an injury will not come most likely from a repair if the repair is done correctly, meaning you're repairing the spare parts with the same spare parts. You're not creating any issue with the repair itself, so you're not breaking a piece in the process. Also, I mean, you have to consider that repair services are local services, most of them. So why would they be caught by European legislation that normally is supposed to address cross-border dimensions of the single market for a service that will be provided mostly locally? That's also a question mark. And in that case, we believe that national law on liabilities are actually fully efficient to address the problem of faulty repairs. So for all these reasons, we think that there's a good benefits of having this approach to actually only make an operator being considered as a manufacturer when it actually does a substantial modification of the product. Now, the second area I'd like to comment on is relating to marketplaces that was actually commented by Urs from Berg before. And here we see that Article 7, the way it has been actually conceived, contains a big loophole here. Because the Commission proposal explained in its explanatory memorandum that it's actually trying to ensure that you will always have an economic operator inside Europe that can be liable. And we very much support that. The problem is that when you look at the detail of Article 7, it's not always the case. And you have one big flow of products that can be sold online through marketplace that escape basically this rule. Because if you look at Article 7, you have basically Article 7 that provide that a platform can be liable if it meets the conditions of Article 6.3 of the Digital Service Act. But what about other cases? So in other cases, you can very well have actually a trader based wherever in the world, not in Europe, selling a product through a platform for which there's no EU-based manufacturer, there's no EU-based importer, and it can do so without using any fulfillment service provider in Europe. So that's quite possible. And many small and large marketplaces allow that possibility at the moment, which means that if you don't have a fulfillment service provider in Europe that is used, meaning you are shipping by post, basically, you have basically no entity liable in Europe for any remedy as part of the PLD. And that's a big loophole. And that loophole should be corrected by, and that's the solution that we propose, by actually including a residual liability for marketplaces when you have this case where no other entity is in Europe. Basically. We're a bit wondering how come this loophole can come from, and we believe that quite possibly it comes from a misinterpretation of the conditional exemption of liability under the DSA. Because you have indeed the Digital Services Act that provide that marketplace or platform in general have a conditional exemption of liability. But when you look at this conditional exemption of liability, it's only applicable to the information that is hosted on the platform. But a defective product is not an information, actually. So there's no reason why the conditional exemption of liability under the DSA would apply to what is regulated by the scope of the PLD. And that should therefore not actually provide a condition to basically prevent from including a new residual liability for platforms, precisely in the case I mentioned, so when you have no EU economic operator at all. So we would therefore recommend clearly to introduce this residual liability for platform when you have no EU-based entity, so no EU-based manufacturer, importer, or fulfillment service provider. And that could actually be completed with a recognition of the right of platforms, marketplace, or even a fulfillment service provider to take legal actions against the operator that actually sold the product. But it's very important to make sure that indeed, as is actually the prime goal of this revision proposed by the Commission, to make sure that there will always be an economic operator in the EU against who liability can be enforced. I'll stop it here, I think, because we have little time left, but I really look forward to contribute to the discussion. Thank you very much.
Thank you very much, Alexis Varavka, for these words, and also I mean, this insight into marketplace is problematic. And now we have the pleasure to have Fabian Junge. He's a legal and policy officer of the Unit for Digital Transformation of Industry in DG Grow. And since joining DG Grow in 2016, Fabian has held different positions related to the digital economy, the single market for services, and the enforcement of union law. And apart from this proposal, he has also worked on other legislative files in this connected to it, most notably the Data Act, but also the Platform to Business Regulation. And he might even answer one of the points directly, but otherwise in the discussion. But right now, you have the floor to give us a brief regulatory update from the European Commission and feedback on the various initiatives. You have the floor. Thank you very much.
Yeah, thank you very much. It's a great pleasure to be here, and also a big thanks to the ELI for being so invested in the revision of the PLD, and especially for raising the interest in this fascinating piece of legislation with the papers, webinars, and of course, even with the draft proposal. This is highly appreciated from our side as a big contribution to the debate. Yeah, I was asked to give a brief regulatory update. Before then reacting, I think that makes it most interesting directly to the points raised by previous speakers. At least I pick and choose to stay within the time limit. Of course, I don't speak on behalf of the co-legislators, but what I can tell you is that both sides, so in Parliament and also in Council, they have widely acknowledged the need for a revision of the PLD. Of course, as usual, the discussion and the core question is whether we got the balance right in our proposal. And this discussion is already in full swing in Council. And this discussion will also start shortly in the Parliament as well, with Juri and IMCO as the responsible committees. So we are very much looking forward also here to support the co-legislators in the next month in assessing whether we got it right and where we can improve it. And then I think the easiest way, if I just answer maybe some questions or clarifications, or also address concerns that have been raised, and maybe I just start, because it's been one of the main topics, the inclusion of standalone software. And in that regard, our approach in the proposal, as you have correctly identified, is that it is included. For us, this is a clarification. There was a parliamentary question in 1988 that was responded to by the Commission already back then that said, yes, software is a product. And beyond that, we have also good reasons to do so. On the one hand side, we have, for example, the medical device regulation, which explicitly recognizes software, standalone software, as a product, medical device. And on the other hand, our approach has been that any product that can cause the damages that we have should be included as a product. For example, it's not just the data loss that we have now included on addition, but if you, for example, download a battery saving app on your phone, and this is defective, causing your battery to overheat, there can be property damage to the phone itself, but of course there could also be personal injury if something burns your leg. So in that sense, having on the one hand side on product safety, clear examples where standalone software is recognized as a product, and on the other hand, where we have clear use cases, scenarios where we can see that damage that is covered under the PLD can be caused by standalone software, it is only fair, in our opinion, to include those. Of course, bearing in mind that the liability under the PLD works as a reverse funnel. So even if you are a product with standalone software, this still means for the claimant that the defectiveness needs to be proven, there needs to be the causal link to be proven, and you actually need to prove the material damages that you have received. So in that sense, we believe that it is a balanced approach to include standalone software, and this is why we also have it in the proposal. Linked to this, maybe also has been mentioned also by the speakers, open source, free and open source software. We have included in the recital, that is correct. But for us, this was more of a clarification, because the limitation doesn't come from labeling something as free and open source software per se, but it comes from the definitions of the new legislative framework for placing on the market, making available, putting into service, because those explicitly refer to commercial activities, which means for us that if something is not done in a commercial activity, it wouldn't be in the scope of the PLD. So in that sense, of course, it's a choice whether to put it in the enacting terms or not. But clearly for us, this should be, or this was the choice in the proposal, that this should not be included. Then maybe I'll continue with also something that was mentioned, which is the liability of online marketplaces. Of course, we all still have the discussions from the DSA and the General Product Safety Regulations in our heads. For us as Commission service, the decision of the co-legislator to adopt the DSA, which includes the provision on conditional liability, was the yardstick. This is what we rely on as the standard for assessing whether online marketplace should be liable or not. We heard that there is maybe a misinterpretation, but from our understanding, and we work closely with the colleagues that have developed the DSA, that were part of the negotiations, the way we have done it so is in full compliance with the DSA, also ensuring, of course, coherence with other union law, as we always try to achieve in our proposals. Then maybe I continue on the fact it was also mentioned on that we refer to substantial modifications. Indeed, we have included substantial modifications because at that point in time, with this action, the risk profile would change, which then should, in our view, also cause a change in the liability allocation. Repair is for us not relevant in this regard, because a repair service, in our sense, or in our understanding at least, would mean I repair something for a client and I give it back. So there is no subsequent making available to someone else. So this also would, in our view, not really warrant a change of the allocation. And similar for refurbishment, it would mean for us a restoring to the original state, which also makes it more difficult to reallocate liability to such a refurbisher in comparison or to someone that actually substantially modifies. In any event, for all these activities, the original manufacturer, of course, still has the defensive available. If there was a defect that was caused by a refurbishment, that was caused by a repair, the original manufacturer could, of course, say, okay, this defect as it is now was not existing when I actually placed the product on the market. So in that sense, it is a policy choice to limit it there, and this is what our evidence provided us with. Then what else do we have? I did it on the spot, so I don't have a proper structure, but I still have a few minutes, huh? Okay. Yes, maybe also something, because it was also coming on the damages. First and foremost, our approach has been to clarify what actually could be covered as damages under the PLD. It is clear for us that it should be material harm, meaning something that is objectively quantifiable in monetary terms. And in that regard, immaterial damages, for example, emotional harm, sadness, seems to be very difficult to be objectively quantifiable. That's why they are called immaterial harm. And for us, this would not be covered and should not be covered as a primary damage in the directive. On the addition, and maybe also here making the link to this, we explicitly now clarified that psychological harm medically recognized would be covered as personal injury. Our evidence gathering showed that in virtually all member states, this is recognized and accepted. So if it's medically recognizable, if it's pathologically recognizable, and psychological harm should be treated as personal injury and not as immaterial harm. We are following this line in that regard. Data loss also for us here is not immaterial harm, as has been claimed in some submissions, but this would also be only covering data loss which you objectively can quantify, which, for example, also by analogy with tangible objects, if I buy a PDF, if I buy a movie and it's on my data, on my device, and there is a defectiveness that causes the damage to that, I should receive this data loss, this material loss back if it's caused by the defectiveness of the product. What else? Maybe also, yeah, of course, Urs mentioned, as expected, that the reversal of the burden of proof would be a better approach for the proposal to make the PLD more effective and more efficient. Of course, that is a discussion that has been going on for decades. We have assessed this in our impact assessment, and we evaluated that reversing the burden of proof was disproportionate and would upset the balance that we are trying to now basically achieve with the proposal. We also assessed that the measures that we have now introduced in the proposal, which means, for example, and you mentioned it as well, the two presumptions or the several presumptions to alleviate the burden of proof, linked also with the possibilities now to actually receive information from the defendant, and also with the lowering of the threshold for the burden of proof in case of excessive difficulties, we believe that we can achieve a comparable impact compared to the reversal of the burden of proof, but with a lesser regulatory intervention. And yes, on maybe then I'll take some points also from, of course, the initial speakers in the beginning. I can agree with what Bernhard said, that in fact, software as a service should be included in the product. This was our intention. We have also tried to address that situation in the recital. Maybe it wasn't clear enough, but what should have been clear is that our policy choice was that to include software irrespective of the means of supply. And that it doesn't matter whether something is supplied to me via the cloud or whether it's stored locally, if it has an impact on functionality, if it can cause the damages that are covered by the PLD, this should also be within the scope of the product definition. And equally for related services, there we changed it a bit and only added it to the component definition because that software would be considered already under the product definition. And what we had in mind there is especially services that would have a direct impact on the functioning of something, for example, a voice assistant that could allow you to control another product, or in the future, if you have an autonomous car and you rely on a navigation system that is the one that in fact drives your car, and if that would be defective, that would have a direct impact on the car veering off the street, for example. There would be a damage, there would be a causality. So here we also found it justified to include these kind of related services. Whether the definitions are as clear as they should be, I fully acknowledge that we can maybe improve this, and we're very much open to receiving suggestions in that regard. That also covers, of course, what Bernhard mentioned in the beginning, fulfillment service provider definition, authorized representatives and importers. We acknowledge that there is maybe the need for a clarification. And then maybe just one last point, of course, on the chapter 3, Christiane mentioned it. It is a very appealing approach to look at these kind of monitoring obligation, but irrespective of that it has an appeal, our evidence gathering before drafting the proposal and before publishing it did not really identify a gap. So for us, it would have been very artificial to come up with something that is actually rather close to fault, as you said, but also, of course, in order to make it very effective, we would have to expand the damages. We would have to potentially expand the list of economic operators that would be liable, and all that without having actually a market failure or regulatory gap clearly identified would, I think, be overstepping what should be achieved by the proposal. But nevertheless, of course, a very interesting discussion to be had, I would say. And I think with this, I leave it. Thank you very much, Pascal.
Thank you very much, Fabian, for these various points. Very useful also to react directly on the various points. And as you know, the ELI has filed a number of points. And so I'm happy to hear that you will, of course, take that into consideration and hopefully implement everything one-to-one. No, I don't pretend that, but of course, take that into consideration. In the meantime, we got also a couple of questions also in the Q&R, and that's also the time to remind everyone that questions might be put in the Q&R. Now, sometimes questions seem to be quite long, so I will try just to summarize because, of course, we will not read all through. But one question that came by two people was linked to a source code of software and whether this source code as piece of information as such should not fall under the notion of product and should be considered as other elements. And for instance, recital 12 mentions operating systems, firmware, computer program, and so on. But what about source code and what is exactly the position? And maybe I could ask you, Fabian, if you could react, because that's a very specific point and you have probably put a lot of thought in it.
Yes, in fact, thank you very much for this. It's a very good point. And Bernhard also mentioned it in the beginning, of course. We did not, and I didn't mention it, we did not include the definition of software per se, because in the discussion, we felt that doing so, it would be ultimately not future-proof. If you think about 20 years ago, software would be a computer program, but if you limit it to that, then applications coming up now wouldn't be covered. So there is probably the need, and we acknowledge that certainly now, to maybe be clearer in the recital. What could that mean for us is exactly what Bernhard said as well. It's the functionality. So it needs to be self-executable. So that already limits, I would say, the possibility to include software in itself, but more importantly, software for us is pure information. I think we also, in one of the recitals, we referred to that, where we basically try to incorporate the judgment of the Court of Justice on the Krone judgment, where it was basically, stated that pure information should not be considered as a product. And this makes sense for us because pure information will not have the functionality, will not have the self-executing means to actually cause the damages that we would be covering. So it's not a product for us, it's pure information.
So even just to be clear, linked to the question, the source code as such, right?
Yes, exactly. And this is why maybe also then, if you allow me, sure. This is also why we actually included in the definition of product digital manufacturing files, because those would be in principle also pure information, but due to their usage then with 3D printing or like one of the, in German it's the Fräsen, and those machineries basically copy or reproduce what these digital manufacturing file contains, and that's why we thought in these kind of situation they are a copy of what then exists as a tangible product ultimately, and that's why these specific types of files should be included as a product.
Thank you very much for these additions. Now we have another question linked to the cascade and especially the issue that was also raised by Karina Stan, linked or maybe it was Alexei Waravka, I'm not more sure, with the issue of developers that are outside the EU, but for instance, a software which is then exclusively digital and that is distributed within the EU. And the question in sum is whether that would not mean a potential disadvantage for the EU software developers compared to the non-EU developer, as long as you have, of course, an EU entity operator that is liable before the non-EU software developer. And in a way, on the one hand, you have an EU software developer that is liable directly, so to say, and a non-EU software developer that will not be liable because of the cascade. You have first, of course, a point of an operator that is within the EU, which is, of course, linked to the structure and the DNA of this directive, it seems to me. But the question is really, would that disadvantage, so to say, of EU software developers has been taken into consideration, and what would be the answer to give to those EU software developer? And it goes in line probably with Karina Stan's concern when she mentioned that. So I don't know whether Karina Stan, you want to add something on that, please.
Very quick, just to fully agree with this observation. And yes, indeed, this is our concern. And that's why I also mentioned the Cyber Resilience Act, product safety regulations. So we will have software that will be CE marked, and consumers will be able also, because we need to see the reality, we will be able to use software from outside Europe and very well. And those developers, of course, won't be burdened by this. So we can see a clear disadvantage for EU developers, unfortunately.
But at the same time, of course, these developers will have the label of EU software developers linked to the Product Safety Act, the Resilience Act, and so on, that will indicate that the quality produced is better, and therefore one should privilege EU software developers. Or am I overdoing it?
Well, in the end, well, we can have that perspective too, but in the end, it's a pure commercial choice, a pure business decision, and of course, it will be, if it will be less costly, to develop something in another jurisdiction and then to provide it to other markets. I mean, there are, for software, also, we need to see that it is a global market. Usually, startups tend to think about growing at scale exponentially. So they look at the global market. So I think there are clear constraints on the growth of European startups because they will compete based on costs also, not only on, it might be a great product, but if it's too costly to develop in Europe, the choice might be another jurisdiction, unfortunately. And also we have to see if really we achieve the objective to protect consumers, because of course, EU developers will comply with the regulation when placing their software on the market, but consumers won't be covered when accessing products outside the EU. So, do we achieve the objective?
Maybe I can give the floor to Fabian Junge to react if he wants. And there's, of course, linked to that the question of marketplace, online marketplace, because often these software will enter the EU through online marketplace. Of course, not necessarily, but that might also induce a marketplace operators to take that into account by having different prices or different requirements for non-EU operators. At least, I don't know, Fabian, do you want to react?
Yeah, of course. I mean, more generally speaking, the list and this expansion of economic operators is, of course, very much designed with a way to be coherent with the market surveillance regulation and also with other product safety rules, but also the DSA. So this was one of the approaches that we decided to not reinvent the wheel there by introducing new personas and new requirements that would be on the manufacturers, for example, or the economicals in general, creators of software. From what I now understood, the discussion here, of course, basically the problem that you're facing, and this might be a potential gap, is that if someone is damaged by a software that is then purchased from the other person outside the EU, and that of course is something we have to discuss, and grateful for this for mentioning this in particular. And Karina, surely if you have more concrete examples in the scenario and the use case where we can clearly see where the gaps are, I would be very grateful if you can share this with us, and then we'll think about it. A direct answer I have not at this point in time.
Yeah. Thank you very much. We have a further questions in the Q&R linked to AI liability directive, and also the contrast with some tort law, domestic tort law, both on the issue of presumptions of causality, but also on the damage that might be repaired. And the question is therefore whether it's a more general question, but do you think that these new rules must or will have an influence on general non-contractual liability rules at national level? In a way, going forward with the PLD, covering larger issues, more damages and so on, it may induce the national legislator also for ordinary non-contractual liability to come up with a broader theme? Or should we consider that some aspects have no more been in the scope of domestic legislation, so that there will not be a spillover effect, but rather the contrary, legislator thinking this is dealt with by the PLD, and therefore why should we, and of course the transposition of it, why should we care more about it? Jean-Sébastien, you mentioned a couple of points linked to that, so maybe you may begin by a general comment on that, if you want to.
Yes, well, it's a very interesting question, but it's hard to predict what impact that there will be on national laws. I would think that it will depend a bit on what national law, what the national judges find interesting. I mean, it seems to me that at least in several legal systems, when there are interesting ideas coming from EU law, at least in tort law, courts and potentially the legislator have been willing to take them over, so to say, whereas they have resisted other ideas which they didn't find so appealing. So, I mean, there are several some legal systems are clearly very plaintiff friendly. I mean, if you take my legal system, France, for example, it's quite plaintiff friendly, at least as far as the general principles on liability are concerned. If you come to compensation, it might be another question. But anyway, if something comes from the EU which goes towards, broadening liability, it will probably be well received and may serve as a source of inspiration. If it goes towards tightening liability, it will be very different. I mean, just to take an example on product liability, before the 1985 directive, we had in France strict distributor liability for defective products, which we had to abandon because it was contrary to the directive. And this hasn't been very well received, and it certainly hasn't spilled over on other aspects of French law. But then other aspects of the directive, such as the double delay mechanism, so one normal prescription delay and one long stop period, that has been extraordinarily influential in French law, and we have changed French law to generalize the double delay, which previously we don't have. So I think it's not possible to give a general answer, but there's certainly a function of toolbox of EU law where you find new ideas, new mechanisms, where national legal systems can kind of pick and choose even beyond what is demanded by EU law. But maybe other people have something to say on that.
Yeah. Thank you. Maybe before or linked to that, just one question to Bernard, linked to software and this distinction between product and services that has been mentioned by Karina Stan, saying it's difficult sometimes to see whether it's a service or whether it's a product, and therefore how to do it. And I was just thinking, linked to that, all this AI liability, of course, is also a question between product and service. If you think on ChatGPT, because we cannot have a webinar nowadays without mentioning ChatGPT, how to consider it and whether, what will be the impact. Of course, there might not be liability for what ChatGPT says or does or writes, but anyway, let's see what you think about it, Bernard.
Well, I could start by saying that I'm not personally here, but just an avatar of mine. So, but
how to prove it?
No, but seriously, that is obviously an extremely tricky question. So I don't envy the Commission for our calls to make more precise definitions in this regard. But there are a couple of follow-up issues, obviously. I'm not so much concerned about the problem of AI as a software, which, of course, makes perfect sense. I mean, I think the bottom line of the whole directives regime, obviously, is we only have a certain limited range of compensable harm. And so issues like pure economic loss and things like that are already out of the game. So you need very specific types of harm, and it's hard to imagine how ChatGPT will produce personal injury or something like that, or property damage, for example, just to use that example. However, by including digital services, or at least some of the digital services, it will get difficult to align this with even the Krone case law, for example, because the court in Krone said explicitly, because the current directive does not include services, we obviously don't want to expand it to include recipes for disaster with horseradish. But now that we explicitly expand it to some digital services, that argument is lost. And the problem is, obviously, if you start by including digital services such as navigation services, the major problem of that being flawed is the navigation data, the map data, not so much the navigation as such. And drawing the line there would be extremely difficult, because it makes perfect sense, obviously, to say the navigation software per se is flawed. So if the map data is right, but it nevertheless tells you to drive into the river, which is on the map, then obviously the navigation software as such is flawed. And that is a service as well, because it's a continuous supply. Or weather data, for example, and stuff like that. Let's say the data says the road is perfectly fine. The temperature is above 4 degrees centigrade. So there's no ice on the road, but in fact, it's a completely flat ice surface. So how do you distinguish between the supply of data as such, the supply, and the data? So that is an extremely tricky question, because if you say that, for example, navigation software as a service should be included as a component in the sense of a continued digital service, which makes sense, of course, because it is crucial for the functioning of the initial product, of course, the self-driving car, for example. But where do you draw the line between the information per se, and can you justify otherwise excluding information in other contexts, standalone information? And I understand the need for the distinction and for keeping it separate, but I'm not really sure how to draw that line.
Thank you very much. Maybe Christiane, you could react, because you made also this link with the product safety regulation and well, which type of information fall under the product safety information if we take now these maps, for instance. And of course, everything is linked in a way, and maybe you want to react on this too.
Yeah, thank you so much. I mean, product safety law is a moving target, right? As it's being revised, and we see an increasing number of project safety pieces of legislation where software is included. In a way, the medical device regulation was the first big piece of legislation where we had an explicit reference to software, and we see a lot of very helpful guidance, actually, which we can derive from the medical device regulation. Maybe just to mention that a way to avoid some of these problems with delineation would have been to adapt the scope of application to what we see in the DCD, the Digital Content and Services Directive, and right away to refer to digital content and digital services within the scope of the DCD. That would have avoided some of the really, really tricky issues of delineation we are seeing now. Of course, it would still have, it would have solved the problem of where you draw the line between the chronic case on the one hand and the functionality. But I think it's really the point of functionality that would be the appropriate criteria. It's simply a difference whether you kind of have a data feed that makes the car turn right instead of left and then cause an accident, or whether you publish something in a newspaper or on a website and then somebody draws a false conclusion and takes the wrong decision. For example, as Bernhard said, a disaster following a recipe with horseradish. So I think it will never be absolutely crystal clear. There will always be hard cases and delineation issues, but including digital content and digital services within the meaning of the DCD would be a certain alternative.
Thank you very much for this very clear statement. We are coming slowly to an end, so maybe I wanted to give the last word to the EU Commission, so to say. And so, Fabian Junge, if you want to react or say a final word, you're welcome, and then I will conclude.
Yeah, thank you very much. I enjoyed this discussion very much, I have to say, as usual. Maybe I just take what Christiane said just at the last point, because of course we were considering including that. But if you look at, on the one hand side, the definition of digital content in the DCD, that basically means any data. And that seems to be a step too far for us, because indeed this element of functionality with any data is not given, and then referring to any data in the light of the Krone judgment referring to information also seems to be too broad in the scope. Because, I mean, that would mean that any media file could be potentially a product in itself, which then, I mean, how do you navigate liability for economic operators? Because this is still what we try to achieve here. It's a balance. We have, of course, included a lot of alleviations for claimants, clarifications to help them advance their claims. But ultimately, what you also need to have in mind when developing, of course, and discussing this is the insurability and the liability exposure of manufacturers. So there we found it difficult. Equally, the notion of digital service in the DCD also refers to two specific types of digital service, which we found then too narrow. I think it refers to basically social media and cloud services, if I recall correctly. And this is not necessarily what we wanted to cover, because as you said, Christiane, we want to cover something that has this element of functionality. And that's why we also wanted to make sure that this element of functionality is part of the discussion when we speak about related services that can have an impact and can have ultimately the potential to cause the damages that we want to cover. So just to explain why we decided to go ahead with what we have now included, but of course, those are very relevant discussions, and I would suggest we continue discussing this, specifically whether it makes sense, because indeed, ultimately, whenever this becomes law, it needs to be applied by judges and legal practitioners. So we need to be clear on what we want to cover. and we need to make sure that claimants actually benefit from it, and we need to make sure that manufacturers know their exposure and still can find the insurance solutions that they actually need to cover for their liability.
Thank you very much. And indeed, maybe also one difference between the PLD and the DCD is in the DCD, parties may in advance modify the consequences in their contract, whereas for the PLD, not necessarily. So, of course, if you have the same definition, you do not have the same means down the road, so to say, to adapt to the various cases. But I see what you say. And I have to say it's time, so I'd like to really thank very, very much all our panelists today. We got very positive reactions also in the Q&R about the quality of the discussion and the presentation. And I have to say it was fun chairing this webinar today because like always, but here and today in particular, all panelists were really on the point, brought very interesting insight. And as I've said at the beginning, of course, the discussion will continue around this PLD, and also with the European Law Institute, we will continue to look very closely at what the EU is doing and what the co-legislators are doing, trying to help where we can help and trying to, some people would say nudge when we think it should go into the right direction. So thank you very much. Thank you for all attendees. And I wish you all a good continuation in your day and in your week. Bye-bye. Thank you very much.